Thank you for joining us today on the 28th of July 2020 for our webinar presented by the Trust Partnership and Stone King called Incorporation for Almshouses, Why and How, an Almshouse Toolkit. I'm Elizabeth Fathi, Director of Almshouses at the Trust Partnership, and I'm joined by Tim Rutherford, who's Partner and Head of Stone King Charity and Social Enterprise. As webinar attendees, your computer cameras and your microphones are turned off, but you will be able to communicate with us to ask questions at any point during the webinar via the Q&A function. So if you look at the right-hand side of your screen, there's some square boxes with circles inside, and the one that says questions, please type in your question there. It will be sent directly to us and will be anonymous. We'll try and address as many questions as we can today. If we run out of time, we'll try and answer them after the seminar. And finally, in the next few days, you'll receive a copy of today's presentation and a link to the webinar recording. So you can watch it again, or you can share it with colleagues if you wish to. It will also be on the websites of the Trust Partnership and Stone King.
Hello, well, I'm not sure if Liz has frozen for the rest of you as well, but I think we're having a slight technical issue at that end. So if I move us on forward, so in terms of the agenda for today, what we're going to look at is why you would want to incorporate and are there alternatives, what structure you would choose to adopt, how you would incorporate, when you should incorporate, and what comes next. Well, before we do that, we've got a few starting questions. So many almshouses have existed for centuries and for many decades and all use different structures. So it may be that currently you are unincorporated, in which case you'd have a scheme or a charitable trust or a will trust or a royal charter. Alternatively, you might already be incorporated and use the structure of a company limited by guarantee, a CIO, or a corporate trustee. So first of all, a few initial questions, and one we quite often get asked is, if you're a new trustee, how would you know if your almshouse charity was already incorporated? And the simple answer, of course, is that you could speak to your co-trustees. Liz, are you back with us?
I am back with you, and I can see you, but can you hear and see me? I'm so sorry, I don't know what happened there, and I was talking away.
That's all right. We've just moved on to a few slides in, so we're on to the questions. So we're looking at the first question: if you're a new trustee, how would you know if your almshouse charity was already incorporated? And the answer to that is, of course, you would ask your co-trustees to start with, but it's quite fair to say that occasionally we find that none of the trustees can completely be honest about knowing what the structure is. So if that's the case, the best place to go is the Charity Commission Register and look under the Charity Framework tab to see what the governing document is. And if you're incorporated, you will either have a document referred to as Articles of Association, if you're a company, or if you're a CIO, a charitable incorporated organisation, it will say that. And we'll be looking at those structures in a bit more detail later. But if you're unincorporated, it will normally just refer to a trustee or a scheme.
Brilliant, thank you. Can I just ask a quick question in there, Tim? Can we be absolutely sure that what's on the Charity Commission website is correct? Because it might be that you've put something that somebody else has actually filled that in, who's a member of the charity. It's not a Charity Commission piece there, is it, on the Charity Commission website?
So what's on the Charity Commission website will be correct as far as the Commission are concerned, but unfortunately it is the case that sometimes people have amended things by passing a resolution and not filed this at the Commission, or occasionally a scheme hasn't been recorded. And also we have found circumstances where the Commission have made reference to schemes that don't exist and so on. But 99.9% of the time that should be correct.
Brilliant, thank you. So that's how we can find a copy of the Charities Constitution as well, isn't it? Because you can get one from the Charity Commission?
Yes, that's right. If you haven't got one, obviously one point of access might be your solicitor. If you've got a regular solicitor you use, who might have it. But if not, you can request a copy from the Charity Commission.
And is that something that everybody needs before they incorporate?
Well, ideally, yes, because in particular, you're going to need to know the trusts on which the almshouses are held, and also who's responsible for appointing trustees and whether any third parties have any rights, because those things would need to carry over into the constitution of the incorporated entity.
Okay, brilliant. So on to the next slide. Will the charity scheme always exist, even if there are articles of association? I know some people get slightly confused because they have a scheme and they have articles.
Yes, and this will become a bit clearer when we go on and look at the process, but the scheme will always be there because it sets out the trusts on which the almshouses are held, and because these are almost always permanent endowment trusts, the scheme continues to be relevant. If you've got separate articles, those would relate to the corporate charity or alternatively to a corporate trustee entity, but the scheme would still be relevant.
Okay, and it's the scheme that actually contains things like the 28-day rule and how to set aside an appointment, those details which are not always in the articles, are they?
That's right, because again, those relate to the permanent endowment trusts, which are relevant to the almshouses and how the almshouses are operated. So again, you would look in the scheme for those particular provisions.
Okay, and if a charity stays unincorporated, does it mean that their constitution's not fit for purpose?
No, and this is something that quite often comes up because we've heard a lot in recent years about the death of the charitable trust and the death of the unincorporated charity. But the reality is that many charities, and in particular almshouse charities, have been around for hundreds of years in an unincorporated form, and it's a perfectly satisfactory form for a charity to take. The main difference, though, is if you were to set up today, you would almost certainly do it in corporate form for a variety of different reasons.
Which I'm sure we'll come on to. So would you like to tell us why we should or why we would want to incorporate?
Okay, well, the straightforward answer is there are essentially three drawbacks of unincorporated charities. Now, the first issue is that an unincorporated charity doesn't have a legal identity in its own right. So strange as it may seem, the charity doesn't actually exist as an entity. It's actually the trustees who are the charity, and the trustees collectively agree to hold the assets of the charitable trust and use them in accordance with the trusts that have been set down. Now, this creates various complications because it means if you own a property or investments, you have to register them in the name of the individual trustees, not a charity name. And then when you change trustees, you have to update those registrations. If you employ a clerk or a warden, then the employment contract is actually between the trustees individually and the individual and not with the charity. Now, if you're a corporate charity, the charity exists as a legal person in its own right. And therefore, if it owns property, it's registered in the name of the charity. If it enters into a contract, it does it in the name of the charity. The second drawback of unincorporated charities is that many of them were established decades ago, in some cases centuries ago, and they tend to have fairly outdated constitutions that don't deal with the provisions that you need today. So, for example, the provisions we've looked at in previous webinars, like online meetings or resolutions by email. But the biggest issue, and what is normally the main driver to think about incorporation, is liability. And that's because in an unincorporated charity, the trustees have unlimited personal liability. Now, trustees can expect to be indemnified from the assets of the charity or take out indemnity insurance, but that isn't necessarily sufficient protection. So, to give an example, imagine one of your residents slips on a broken paving stone on the communal path and suffers a personal injury. Their first course of action when they get back from the hospital might well be to bring a personal injury claim against the charity. Now, if you're unincorporated, that claim will be against the individual trustees in their personal names. And if the claim is successful, then the trustees will be found personally liable in their individual capacities, and that's a joint and several liability, So each trustee is liable to the full extent. Now, clearly, the first stage then will be to claim on your insurance. And in most cases, your insurance will pay out, you hope. But as we've seen recently in the pandemic, lots of businesses thought they had business interruption insurance and have now discovered that actually they don't, or it doesn't cover them for a pandemic. So you need to be aware that your insurance might not pay out, your treasurer might have forgotten to pay the premium, or even your insurer may go bust. So if the insurance doesn't cover the claim, then the next step would be to look at the assets held by the trustees for the benefit of the charity. Now, in most cases, again, the charity's assets will be sufficient to meet the claim. But you do need to consider whether you can use assets that are held in restricted funds, and also whether you can use the permanent endowment assets, and it will depend upon the nature of the claim. So you could find that those avenues are exhausted and that actually it's your personal assets that are at risk. But how would things be different if the charity was incorporated? Well, in this case, the third party would bring the claim against the charity, not the individual trustees. It is the charity that would be found liable, not the trustees. Again, you would go through the process of looking at insurance and then looking at the assets of the charity. But if those assets weren't there or there wasn't any insurance, that's where the claim stops. There's no claim against trustees' personal assets in a corporate entity. Now, that's the main reason most people think about incorporation, because it provides that protection of limited liability. But as we talked about briefly in the last webinar, it doesn't necessarily mean that trustees are in the clear. So there are some circumstances where you can still be personally liable. For example, if your trustee commits a defamation claim or a discrimination claim, or if the charity starts going insolvent and continues operating when it's got no prospect of repaying the debts. And there's also questions around the extent to which it protects against criminal liability. But overall, the risk of personal liability is greatly reduced in an incorporated charity.
Thank you, Tim. I'm wondering if you can still hear me, because I've got some frozen screens going on. So I'll carry on unless you tell me otherwise, in which case I'll switch my webcam off. But I think if we could just say the summary, if you like, so far is that the risks for a trustee of an unincorporated charity are low, but higher than for those of an incorporated charity. So I think that's the message that's coming across quite clearly. Risks are generally hidden in unknown unknowns, and you gave the examples of the insurance claims, which are always the ones that you're never sure, or you don't know whether a claim, or you very much hope claim's not coming your way. And an incorporation is one way of controlling that risk, especially in such a litigious society, which is where we live today. The other thing I wonder is whether incorporation may attract new trustees and try and sort of reassure existing trustees, because I think that a lot of trustees are concerned these days. And so if this is one way to attract trustees that otherwise wouldn't have come on board, then that's another good reason to look at incorporation. But I think what I'm hearing from you is that it's not about absolving the trustees of responsibility, because nothing's going to do that. It's just about having a sort of recognised legal structure where they are considered as one, and it links to the world today. So if you're talking to a bank, or you're talking to a regulator, or Homes England, or enforcers, or residents, or whoever, then it's a structure that people will understand.
Correct.
Are there any alternatives to incorporation?
Well, the answer to that is yes. There are a number of different ways that you can get to a similar place. So the first drawback around lack of limited liability, obviously alternative ways to deal with that are to make sure that you're adequately insured, to make sure that you keep a strong balance sheet and you don't run up significant liabilities. Also, if things go wrong, you could rely on the fact that you can go to the Charity Commission or the court to seek relief from liability, but there's no guarantee that you would get it. Above all, the best way to deal with a lack of limited liability is actually to rely on good governance and make sure you are minimizing risks as much as possible. In terms of the drawback of not having a legal existence in your own right, there are various ways to deal with that. One way is to put in place a corporate trustee. We're going to look at that in a bit more detail later on. Another alternative is to get what's known as a certificate of incorporation, and that does cause some confusion. But essentially what it means is that you've applied to the Charity Commission and received a document that says that you can use a corporate name for your trustee body, such as the trustees of Mr. So-and-so's Almshouses registered. And that then enables you to use that corporate name as a shorthand for the names of the trustees for the time being. So if you enter into a contract, you can enter into it in that corporate body name. However, the one thing people tend to forget is that doesn't give you any protection against liability. It simply allows the group of trustees to use a corporate name as shorthand for all of their names. The other thing that you can do is to use a custodian trustee, so appoint a third party who's permanently there to be the trustee of your property, or to use the official custodian for charities. And many almshouses will have their properties registered with the official custodian for charities, which is essentially just a name that you can use to ensure that the property is properly registered. And then finally, the drawback about your constitution, well, obviously, as we've talked about before in these webinars, you could use a Charity Commission scheme, or you could, in many cases, pass a resolution under the Charities Act to update your constitution. So you could use all of these steps and get to a place that is similar to being an incorporated charity.
Okay, thank you. But the three main ones that we are used to is the company limited by guarantee, where the entire charity becomes a company limited by guarantee, a charitable incorporated organisation, which is the Charity Commission equivalent of that, and thirdly, to keep the charity as it is, as a historic charity, but to have a corporate trustee company in place of the trustees, and then the trustees are directors of that company. So those are the three main ones that we see most often.
Correct. And in terms of incorporation, really, it's the first two. So the structure you would choose is either a company or a charitable incorporated organisation. Now, we're always asked what is the difference between the two, and CIOs, or charitable incorporated organisations, have only been around since around about 2013. And they are actually a corporate structure that is pretty much modelled on the structure of a company limited by guarantee. So they are very similar, but it's a structure that's only available to charities and is registered solely with the Charity Commission. And it's always very difficult because people ask us to say which one is the right structure for them. And there are advantages and there are perceived disadvantages. So the advantages of being a CIO is that you only have one regulator, the Charity Commission. If you set up a company limited by guarantee, you're accountable to the Charity Commission and Companies House. If you're a CIO, you're not covered by company law. And if any of you have had to read the Companies Act, you'll know it's in a book about this thick, whereas the bit of the Charities Act dealing with CIOs is much smaller. And the problem sometimes for companies is that there can be changes in the Companies Act that affect charities by accident without people realising. But in most cases, those issues tend to get resolved quite quickly. Currently, you don't pay any charges to be a CIO, whereas if you're a company, you would pay a small annual charge to Companies House. The reporting obligations are slightly less for a CIO. When you change trustees, you only tell the Charity Commission, you don't have to tell Companies House as well. You only file your accounts in one place, and so on. There's a technical advantage to do with permanent endowment on incorporation, and we'll look at that in more detail later on. And I think the biggest advantage of a CIO is that it is something that is actually meant for charities. It has the word charity in the title. Many charities that incorporate as a company limited by guarantee sometimes struggle to explain whether they are a company or a charity. And you explain to people, well, we are a company, but we are registered as a charity. And people say, yes, but are you a company or are you a charity? And because you have two different numbers, a company number and a charity number, it can get even more confusing. Now, it's also fair to say that there are thought to be some disadvantages of CIOs, but really since the early days, I think we moved on slightly, and this is why I would now refer to them as perceived disadvantages as opposed to actual disadvantages. First of all, it was thought that it was a new and untested structure, and that isn't really the case anymore. About 12% of all charities are CIOs, and each year, around 2/3 of the new charities being formed are CIOs. So last year, out of 6,000 new charities, about 4,000 of them were CIOs. It was also thought that there could be gaps in the law, and there may be, but again, in most cases where in the past people forgot to include CIOs, they are now covered by the legislation. So for example, the recent Corporate Insolvency and Governance Act that came out to deal with issues arising out of the pandemic actually deals with CIOs as well as companies. It was suggested that CIOs aren't familiar to third parties, and actually in the early days that was quite convenient because banks thought that all you really were doing was changing your name, but that isn't the case now, and actually everyone is familiar with the structure. But there are two big differences which do need to be taken into account. The first one is that a CIO doesn't have a register of charges. So if you're a company and you want to borrow money, you can secure that money over the business of the company as opposed to its physical assets. And you can register what's known as a debenture at Companies House. And that tells people that you've borrowed X amount of money against effectively the income stream of the company. And that if they're going to lend you more money, they're going to be standing behind the person who's already lent you that money. With the CIO, there isn't a similar register of charges. So nobody would know whether you'd actually borrowed money from somebody else. But in most cases, it's very rare for a charity to get involved in that type of borrowing. And if you were actually going to borrow, it's more likely that you would borrow and secure that against property, which would be the same for a company or a CIO and be registered at the land registry. The other issue is that in a company structure, you can authorize conflicts of interest. Now, in your unincorporated form, it's very rare that you would be able to authorize conflicts of interest. And the issue in a company is that actually the Charity Commission don't like you to be able to authorize conflicts. And it's one of those areas where company law allows you something that really charity law shouldn't. Now, in a CIO, you can't do that. If you're conflicted, and you can't be authorized to get around that problem. So some people say that's a drawback. Some people say that actually that just naturally replicates the position that you currently have. So in reality, there's actually very little difference. And the main difference is that the CIO is meant specifically for charities. Now, one issue that is slightly different if you incorporate is that corporate structures have two layers of governance. Unincorporated charities mainly only have trustees, but a corporate structure is based upon a profit-making company that has owners and managers. So in a corporate charity, you have trustees and you have members. And in many cases, they are set up so that the trustees and the members are the same individuals, and they just occasionally wear different hats. And really, in a charitable company or a CIO, the main role of the members is simply to appoint and remove trustees, to deal with constitutional amendments, and also to deal with any dissolution of the CIO or company. So occasionally you'll see charities that have a much wider membership, if you think of something like the National Trust, and then it would be appropriate to have a different membership body. But in most almshouses, we would normally see the members being the same individuals as the trustees.
Thank you. Can I just ask one question on if you have a CIO, do you still have a scheme and another sort of document, or is it wrapped up, or does the scheme get wrapped up into the CIO?
No, in both cases. So in a CIO, you would have a constitution. In a company, you would have articles of association. And in both cases, that's what will set out what the objects of the charity are, how the trustees are appointed and removed, and so on. The scheme will still be relevant because the scheme will set out the trust's on which the almshouses are held, which are permanent endowment. And because a corporate charity can't hold assets that are going to be used for purposes other than the corporate purposes, so it can't hold an asset as permanent endowment, the process, which we'll come on to in a minute, is that the corporate charity has to become the trustee of the permanent endowment trusts, and those remain set out in the scheme. So CIO, you'd have a constitution and the scheme for the permanent endowment trusts. For a company, you'd have articles of association and the scheme for the permanent endowment trusts.
Yeah, the permanent endowment therefore becomes the important thing there, doesn't it, in terms of how that's dealt with, which we will come on to. So the company limited by guarantee means the charity is run as a limited company and registered as a charity. To get the two, charitable incorporated organisation is charity's specific corporate body created by the Charities Act. So what about the corporate trustee as an alternative?
Okay, just before I come on to that, one of the questions that's just popped up is somebody asked about a community interest company and whether that was an alternative. The difficulty with a community interest company is that it isn't a charitable company, and therefore, whilst you could use it in certain circumstances, it's not something you could use as an alternative to a CIO because it wouldn't be capable of being registered as a charity. But coming on to talk about corporate trustees, well, that is another alternative, and it's a sort of halfway house to incorporation. And what you actually do is incorporate the trustee body itself. So you set up a company limited by guarantee that is then appointed to be the sole corporate trustee of the charity, and the individuals who are currently the trustees of the charity then become the directors of the trustee company. Now, a corporate trustee company would have articles of association very similar to a charitable company, so dealing with trustee benefits, conflicts of interest, it being non-profit making and so on. Now, part of the issue is that there are some drawbacks from being a corporate trustee. The first one is that you need to be a trust corporation in order to give effective receipt for land and to hold land. Now, to get that status, you have to go through a process either with the Ministry of Justice or getting the Charity Commission to appoint the corporate trustee as a trustee, and that gives it trust corporation status. Now, the other issue is that whilst this seems great and it's a cost-effective solution because you've effectively just done a change of trustee, the individuals involved have to understand that they are no longer charity trustees, but that they are the directors of the charity trustee. And that's often very complicated to explain to third parties, because what you're really saying is, we as a charity now have one trustee, the limited company, the individuals are directors of that one trustee. And we've seen issues with HMRC and banks not really fully understanding that. And in particular, for example, trustees in those circumstances sometimes continue to buy trustee and officer insurance, despite the fact that what they're actually insuring is the trustee company, not the individuals who sit within it. You also, in this situation, on the Charity Commission register, would just show the name of the corporate trustee company as the only trustee. So people who go and look at the register to find out who your trustees are will say, but you're not a trustee, there's this strange company there. And you'll say, well, that's correct, that is the trustee, but we are the director of the trustee. And then there's also a question about accounts, because the corporate trustee company is only holding the assets of the charity on trust, and therefore they aren't the company's assets. So it effectively files dormant accounts. And you have this strange situation where the charity files full accounts at the Charities Commission, but the company, the corporate trustee, files dormant accounts showing a zero balance at Companies House. And what sometimes happens is people who are going to deal with you will go to Companies House and get the dormant accounts and say, well, you don't actually exist, you don't have any assets. So there are some complexities there. The reality is, if you understand them, and once you've been through them and explained them about 5 times to people and HMRC and the bank and so on, it's fine. But it is that sort of added complexity. But some people do take that route as a route to incorporation. in particular if there are really no unrestricted assets at all and all you're dealing with is permanent endowment, because it's slightly easier.
Okay, we've got a couple of questions, Tim, and I'm just thinking I'm going to take some of them. I think will be quite useful to wrap up at the end to make sure we've understood. So I'll take some of those. We'll take some of those at the end. But just with that corporate trustee, can it be that the corporate trustee does not hold the land and you leave the permanent endowment in the charity?
Well, so if you go down the corporate trustee route, essentially what you're doing is keeping the charity in its current form with the same charity number and in an unincorporated form, but you're taking the trustee company and appointing it as the sole trustee. So effectively everything would stay the same as your charity currently is, but you would only have this one trustee that is the limited company.
Okay, brilliant, thank you. So we need now to talk about the process to incorporate, which does touch on costs, and we've got somebody asking about costs as well. So we'll come back to that at the end of this section. And is a solicitor necessary? I'm not sure you're the right person to answer that, Tim. I'm sure you'll give us the answer though.
Well, the straightforward answer is that it is quite a simple process to incorporate, but there's quite a lot to do and quite a lot to be aware of. Now, unfortunately, there is no simple process where you can simply flick a switch and become a CIO or a company. I know we've had a question in advance that was around whether there would ever be a statutory process where you could just convert in a similar way to a registered society, which has the ability to convert to a company and so on. But there is no process like that. So you have to go through quite a long-winded process of setting up a new charity and transferring everything over to it. Now, it is fair to say that you don't need to use a solicitor for this. It is a process which is relatively straightforward. And if you know what you're doing, you could do the process completely yourself. However, it's fair to give a health warning on that, in that we have been involved in a number of cases where people have done DIY incorporations themselves, and there's a few things they've missed. And sometimes sorting out those things can be more complicated at the end than if you'd done them at the beginning. And part of the issue is that if you read the Charity Commission website, or there's a very good book on CIOs that deals with incorporation, they don't deal with some of the complexities that are relevant just to almshouses. So in terms of the process, obviously the first stage is that you need to set up an entirely new charity. So you need to prepare a constitution for the corporate charity, and there are a few things you need to think about. The first one is that you need to remember that the permanent endowment is staying effectively on the old trusts in the scheme charity. So the objects of the corporate charity need to match the objects of the trusts on which the almshouses are held. And occasionally we find, again, when people have done an incorporation themselves, that they've updated the objects in their constitution for the new charity, maybe extended or changed the area of benefit, and haven't appreciated that you would also then need to amend the objects of the underlying trusts of the permanent endowment, which would involve Charity Commission consent. You also in the Constitution would normally include all of the modern requirements about online meetings, resolutions by email, and so on. And if you're currently a registered social landlord, you'd want to make sure that the new Constitution is compliant to enable you to register the new entity as a registered provider as well. You also want to think about how your trustees are appointed. So it may be that currently you have to have an AGM, or you have to have trustees appointed by the council or the bishop of wherever. And actually, you're finding that those third parties no longer want to be involved or put forward trustees. So you may want to speak to them and say, in the new constitution, we're planning that actually you won't have a role in appointing trustees, and they may be perfectly happy with that. You also need to reflect the fact that as we've mentioned a couple of times, the permanent endowment continues to be held on the existing trusts. And again, quite often people who don't appreciate this don't refer to that in the constitution of the CIO. Now, we tend to find it helpful to actually, in the CIO constitution, say that the CIO or the company will be the trustee of the almshouses, which will continue to be held on the trusts as set out in the scheme dated whatever. And that then gives you a sort of link back to the scheme. So in the future, if somebody's amending the constitution, they know that they also need to amend the underlying scheme. The second stage, once you've got a constitution you're happy with, is to then either, if you're going the company route, to apply to Companies House to incorporate the company and then apply to the Charity Commission to register it. Or if you're just simply going the CIO route, you go straight to the Charity Commission to register the CIO. Then the next stage is once the new charity exists, so your CIO or your company, you have a new entity with a new charity number. And at that stage, you then need to plan how you're going to transfer everything over to it, because essentially it doesn't automatically move over. You need to go through a transfer process. And there are various things you need to do in order to make that process happen. Now, the first issue is that normally the trustees of the old charity and the trustees of the new corporate charity will be the same individuals. And what you want to do is transfer the assets from yourself as an individual to the corporate charity, and in return be given an indemnity for all of the existing liabilities you have as a trustee. But because you're on both sides of that transaction, you are conflicted. So the first stage is you need to go to the Charity Commission to get an order to permit you to make the transfer, notwithstanding your conflict of interest, and also to give yourself an indemnity, which is normally allowed up to the value of the assets transferred across. And again, that's a stage that isn't really telegraphed on the Charity Commission website when they talk about incorporation. Now, if you're going the company route, you do exactly the same, but you go for a slightly different order because you have to comply with some various technicalities in the Companies Act. But once you've got that order, which comes quite easily, the next stage is a resolution to transfer the assets. The new entity passes a resolution to accept them, and then you would normally have a transfer agreement. But you also have to decide how you're going to transfer the trusteeship of the permanent endowment. Now, if you've gone the CIO route, there's a very simple process whereby you prepare a pre-merger vesting declaration, and that has the effect of automatically appointing the CIO as a trust corporation so it can hold land, and then creating it as the sole corporate trustee of the permanent endowment trusts. And it then goes one stage further and says that the CIO and the old charity with the permanent endowment trusts are treated as one entity for accounting, reporting, and registration purposes. So it's a very easy process that you can do yourself, and then you file the vesting declaration with the Commission. If you've gone the company route, there isn't an equivalent process. So you actually have to go to the effort of getting the Charity Commission to make a scheme to appoint the new corporate entity as the sole trustee of the permanent endowment trusts, and then you apply for what's known as a linking direction to link the two charities together. Now, if you're going to simply go the route of appointing a corporate trustee, the process is actually quite simplified. You go through the same step of creating a constitution, you would then incorporate that at Companies House, and then you just simply apply to the Charity Commission for a scheme to appoint it as the trustee of the existing charity.
Okay, so that question about whether to instruct a solicitor, actually the solicitor would do all of that, wouldn't they? They would take care of all of those resolutions and permissions, making sure that the charity did everything in the right order.
Yes.
Brilliant. Okay, so it looks as though the process is about checking the current position, making some trustee resolutions, gaining various permissions, but then there's another stage, isn't there? There's the actual transfer process. Could you go through that for us, please?
That's right. And again, this is another area where things aren't really made clear on the Charity Commission website, because again, Charity Commission website does talk about pre-merger vesting declarations to transfer the assets. It doesn't make the point that that doesn't actually transfer any liabilities. So for example, the utility bills of the old charity, they are a liability, and if you want to transfer them to the CIO, you need to deal with that in a transfer agreement. So normally you would have a separate document that aims to transfer all of those liabilities across. In addition, you also need to make sure that you speak to your bank. So the corporate charity is a new entity, so it'll need a new bank account. And most banks will require you to close accounts and open new ones. Occasionally they let you transfer them, but that's quite rare. So in addition, if you've borrowed money in the past, secured over property, and you've got a mortgage, this would actually be a trigger to repay that mortgage. So again, you need to plan that in advance. If you've got employees, they will technically transfer over to the new entity under what's known as TUPE, but you need to think about if there's a pre-existing employment claim from an employee, actually you want that to transfer over to the new entity as well. And again, that will be dealt with in the transfer agreement. You need to think about whether the old charity has the benefit of some retained interests. So for example, you may have had a bit of land in the past that you sold off to a third party, and in the agreement selling the land to them, you said if you ever build on it in the future, we get a certain percentage of the development profit that you make. And the benefit of that contract would need to be transferred across. You might have an interest in a book that somebody's written about the charity. You may have copyright interests. Again, all of these things need to be thought about, and the benefit of them transferred to the new entity. You also need to be aware as to whether you've had any social housing grant in the past, because again, the transfer of property from one entity to the other can sometimes trigger a repayment of that social housing grant. Now, in most cases on an incorporation, it's possible to deal with a deferral of the repayment of the housing grant by putting in place a deed of covenant with the regulator. But again, you need to know to do it in advance so you don't accidentally trigger a repayment. Now, the appointment of a corporate trustee avoids the need to do a lot of this, but you would still need to deal with the employees because they essentially move to a new employer. You would need to deal with your properties because, again, transferring them to a new trustee would lead to a need to register that with the land registry. And you also might have the same issue with the social housing grant. Now, one point just to mention again on the property, which again is another area that people tend to overlook if they're doing this themselves. The interest in the property will almost certainly be transferred by the pre-merger vesting declaration. But potentially, there is also a need to file a stamp duty land tax return, even though it's a nil transaction. And that's simply because the requirements are that even on a nil transaction for a property, you still need to file an SDLT form. So again, that's something people need to think about. And one other question I'll just pick up at this stage, somebody's asked, if you incorporate the trustee body, can you leave the permanent endowment in the name of the official custodian for charities? Well, the straightforward answer is that you can, but equally, if you've gone through the process of putting in place a corporate trustee body, it is not a lot more additional work to simply change the name on the land registry to reflect the new company instead of the official custodian, but you don't need to. But in many ways, it's cleaner to do that so people know for the future that it's actually the property of the corporate trustee. And then finally, to complete the incorporation, you need to do a few other things. You need to register with HMRC, and that's to be recognised as a charity, also to deal with gift aid, and if you've got employees, to update your PAYE and national insurance details. You need to tell all the people you deal with that you are a new charity with a new charity number. And that's normally a case of just writing to them and saying, we've now incorporated, we're a new structure, this is our new charity number. You need to update your website, your notepaper and your signage, all those places where you use the charity number, you need to put the new number. And also, if you've gone down the route of incorporating and not putting the word CIO in your name or limited in your name, you need to make sure that on your note paper, you actually say such and such charity, which is a charitable incorporated organisation, or which is a company limited by guarantee. And that's so that any party dealing with you knows that you are a limited liability entity. And that's why normally, if you were incorporating as a CIO, we would suggest including CIO as part of the name, because then it avoids having to put all that extra wording on the bottom of your note paper. And then finally, if you've gone the CIO route, the last thing you do is register the pre-merger vesting declaration, and that has the effect of consolidating the old register entry for the old charity in with the new CIO entry.
Thanks, Tim. There is quite a process behind all of that, isn't there? And I think just it's not the same for all types of incorporation as is written there. But I think a couple of the questions we've had are about costs and whether one is more costly than the other, or the corporate trustee is the cheaper. Can you help on that?
Okay, so in terms of going the full incorporation route of either a CIO or a company, essentially the cost is pretty much the same. The company route, there's a slightly small charge of about £100 to incorporate the company, but apart from that, the actual costs, if you were to use a solicitor, would be around the same. But the things that can actually lead to the process being far more expensive is, for example, if you have a lot of unregistered property. So if you have almshouses you've held for 100 years, you're not quite sure where the boundaries are or what the title deeds are, and they've never been registered at the land registry because you've never changed trustees, then you would have to do a first registration, which can be a very complicated process. If you have a lot of employees, so maybe you provide extra care services or something like that, you have a full number of employees, you might need to go through a full TUPE consultation process, and that can involve more money. If you've got complicated intellectual property rights, so maybe you benefit from books that have been written in the past about the history of the charity and so on. Again, all those sorts of complexities can add to the cost involved in doing the incorporation. But for most charities, it will be quite straightforward. It will be a case of dealing with setting up the new entity and some fairly standard arrangements to transfer things over.
Okay, brilliant, thank you. So I think the next slide talks about timing, because you can help the whole process by getting the timing right, or you can do some of the process beforehand and then getting the actual date that it all takes place on by just looking carefully at that timing, can't you?
That's right. So essentially, once you've set up your new CIO or company, it's up to you when you actually transfer things over to it. Now, it's best to do this if you can at a year end, because it means that the old charity can produce some accounts that go up to the end of 1 year, and then the new charity can take over and essentially have a set of accounts that go on for a complete financial year. And that makes things a lot easier for your accountants because they are used to drawing up accounts at the end of a year. But that doesn't necessarily mean that you have to do it then. So you could do it essentially at any point once the new charity is there. You can say, right, tomorrow we want to transfer things over. But in terms of an accounting point of view, it's easier if you don't do it at year end to at least do it at a month end. But the key issue in all of this is planning, because the process of setting up the new charity is the bit that is outside of your control. So you need to involve the Charity Commission, you need to register with the Charity Commission. That can take anywhere between a matter of days and a matter of months. So you need to allow time for that. Alongside that, you need to then be thinking about dealing with your insurers, with your banks, with your employees and so on. But that can be done in parallel. But a good time to allow yourself is up to a year. You can do it in 6 months, but it's better to allow yourself as much time as possible. The longer you allow yourself, the better. If you suddenly say, actually, we need to do it within the next 3 months because we're about to do a massive building project and we want to do it through the corporate entity so we get limited liability, you are going to find that a significant struggle. But equally, if you're halfway through a construction project, that is the wrong time to think about incorporating, because you'd have to think about all those construction contracts and novating them across to the new entity. So you want to allow yourself plenty of time. You want to plan it at a point where you're not doing other things around it. But the key to it is time, and allow yourself the time to go through the process.
But you can get everything ready and then sort of have a trigger date. Is that right? You can get everything just there, and yeah.
Yeah, that's absolutely right. So as I said, once you've set up the new charity, it can sit there completely dormant until you effectively want to activate it. Now, we have in some cases had situations where the new charity has been set up and it's sat there for 1 or 2 years, and that's absolutely fine. The only thing you need to remember is, of course, it is an active charity, so it needs to file some accounts, even though there'll be 0 accounts because there's nothing there. But it's quite straightforward. You just simply file some dormant accounts and a standard annual return, and it can sit there until you're ready to make it go live. Brilliant,
thank you. Just before we get on to permanent endowment, question came through which is a bit relevant to the previous part, which is about if you incorporate using a corporate trustee, do you need to change the name of the bank account and your letterheads, etc. So you talked about the CIO and the CLG, but what about if you have a corporate trustee?
Yeah, so if you're incorporating as a corporate trustee, you don't need to put in place new bank accounts unless the bank says to you that you've got a particular type of account that can't be held by a limited company as a trustee. So there are some banks that actually would make you open a new type of bank account. But in theory, you shouldn't need to, because you're the same entity, you've just had a change of trustees. So in the same way as when you change trustees, generally, you don't have to open a new bank account, you just update the mandate with the bank. And one of the things the bank will want to know is who has authority to sign on behalf of the company. In terms of the letterhead, there is no need to change the letterhead or to make any reference to the sole corporate trustee, because it's no different to the situation you currently have with the individuals as trustees. However, what you will find, of course, is if you enter into a contract, that contract should be with the limited company as the party to the contract. That is going to cause confusion because people are going to say, but hang on, that's not the charity. And so you need to explain in the contract that we are such and such corporate trustee limited as the sole corporate trustee of X charity. And that's the way that you would deal with that. And again, you would need to mention the company and the company number, and then the charity and the charity number.
Brilliant, thank you. I'm conscious of time, Tim, and I've got the benefit of a clock over your right shoulder, so I can see that we've got sort of 5 minutes left, and we've just got to quickly talk about permanent endowment, and then there are a couple of questions that have come through, which I think could be quite useful. So if you could just tell us where that, just so we're doubly sure where the permanent endowment is, because I think that's a crucial part of incorporation.
Okay, and this is the bit that's really, really confusing, and it depends upon which structure you've chosen. So as we've said a couple of times, a corporate charity can't hold permanent endowment as part of its own assets. It has to be holding that permanent endowment on trust, and the way it does that is by being appointed as the trustee of the old schemed charity. Now, if you go the CIO route, the peculiarity of the ease of the legislation by using the pre-merger vesting declaration is that when you use that process, the CIO and the old permanent endowment trusts are automatically consolidated for public view as one entity. So if you go on the Charity Commission register, all you will see is the CIO. You won't see any reference at all to the permanent endowment trust, but it is actually still there. It's just that for reporting and registration purposes, you only have to show the one consolidated entity. And that's why, as we said earlier, in your CIO constitution, it's always good to refer to the scheme, because otherwise you'll forget that it's still relevant. If you go the company route, the process is different. Because the Commission puts in place a scheme and then you apply for a linking direction, if you go on the Charity Commission register, you will see the corporate charity, and then you'll see linked charities, and then that's where you will find the permanent endowment trust reflected. But essentially, the two structures are identical, save that in the CIO, the linked charity is sort of invisible.
And the corporate trustee is the next one. Where's the permanent endowment if a corporate trustee is formed?
In that case, there's no difference to how you currently are as a charity. You go on the Charity Commission register, you will see the current charity, and that obviously includes the permanent endowment trustees. The difference, though, is you would then see on the register, you wouldn't see individual trustees, you would see the trustee company named as the individual trustee, and then your individual trustees would sit above that as directors of the trustee.
Brilliant. Thank you very much. So we look at the next slide, which is to talk just about the next step, because essentially I think what you're saying, Tim, is you've got to start by reviewing what you want. And I think that's really crucial, because what you've said is there are various routes you can go down. And to some extent, it does depend on whether you've got a complicated charity, whether you've got investment property, whether you're in the middle of doing something or you've got plans to do something in the future with sort of contracts and things like that. And I think that what you're really saying is if you really sort of think at the beginning about timing and about where you are in charity history and about what you want out of incorporation, and that might help look at which route is best for you. So I think that's what you're sort of saying. Take advice, I think, because it's a complicated process, and I think to do it on your own potentially there are a lot of rabbit holes to fall down, aren't there, really? So to take advice, to think about what you might need, and then is to make the decision and make that board resolution, which will start the process rolling. So if I've summarized all of that correctly, there are a couple of questions that have come through, and one of them, somebody's just asked if we could just be really clear when you look on your charity commission, when you look on the charity commission website, so when you do find a charity, and then if you look on, I can't remember what it's called, but it's something like Charity Overview, I think, and it just gives what the constitution is. So this person has asked, if it says charter, for example, can you automatically tell that's an unincorporated charity? Are we really looking for the words articles or CIO to know that it's incorporated? And is everything else likely to mean it's unincorporated?
Okay. Yes, so the straightforward answer is you go to the Charity Commission website, you look your charity up on the register, and you go to the tab down the side that says Charity Framework, and then you should be able to look at what type of governing document it says you have. If you are a CIO, it will say you are a CIO and either an association model or a foundation model. More likely than not, you'd be a foundation model because that's the model where trustees and members are the same. If you are incorporated as a company, it will say Articles of Association. If it says your governing document is a scheme, then you are unincorporated. If it says that your governing document is a trust deed or a will trust, then you are unincorporated. The complicated one is that, yes, if it says you have a charter, you could be incorporated or you might be unincorporated. And it depends upon the way that the charter works as to whether or not your trustees are a body corporate, and that has different issues. So if you do have a very complicated centuries-old charter, then you might actually want to get some advice as to whether you need to incorporate or not, depending on how you're actually structured.
And is it quite easy, Tim, for you to see whether somebody is incorporated? So if somebody just rang you up and said, we don't know, because the other thing is it might say Articles of Association, but you will also have a scheme, because we've gone into that as well. But is it quite easy for you just looking at the Charity Commission website, or would it be quite a formal process to instruct you to see whether this charity is incorporated?
No, it's a very straightforward process. And in particular, if you'd gone the company route and you had Articles of Association, you'd also have the linked charity referred to down the side, which is the Permanent Endowment Trust. So that would be quite straightforward. The one thing we can't do is tell you if you've ever obtained a certificate of incorporation for your trustee body, because that is a document that comes from the Charity Commission. It isn't reflected on the public part of the register. It is only reflected on the behind the scenes part of the register available to the Commission. But it's also fair to say, having had recent experience of this, the Commission themselves don't always know whether or not they've given a certificate of incorporation. And the original act that allowed them to do it was from the 1870s, and therefore you may find you got a certificate of incorporation in the 1920s or 30s for your charitable trust, and nobody's got a copy of it. And if you can't find it, then nobody could tell you whether you are or are not incorporated as a corporate trustee body. So that's the only bit we can't do. But in terms of, yes, somebody phoning up and saying, are we incorporated or not, that's a very easy question to answer.
Yes, those blue pieces of paper that say you are incorporated and came to you in about the 1980s are quite confusing, aren't they, really? Because it looks as if you're incorporated, but you aren't incorporated in terms of a separate legal entity. It's a different incorporation.
And most people who got them as long ago as that would actually have a provision in it about using a seal. So if as a charity you use a seal to seal documents, that's quite often a good indicator that at some point in the past you got a certificate of incorporation for your trustee body.
But that doesn't mean that you shouldn't look at incorporation now, because it's a different thing.
No, that's right. And as we mentioned very early on, so a certificate of incorporation simply enables your trustees to act in a corporate name. It doesn't give you any form of protection by way of limited liability at all.
Yeah. And the other thing, just final question, somebody has said, if you were a CIO and there was a trustee, for example, the example was given as a treasurer who'd run off with the money, would you be liable as an individual within the CIO, or would the CIO be liable?
Okay, so if you have an individual trustee who runs off with all of the money, then the starting point is it's actually a claim by the charity against that individual to get the money back. So if you're a corporate charity, it would be the corporate charity that brings the claim against that individual. If you are an unincorporated charity, it would be you as a group of trustees who would go against that individual. In either circumstance, whether or not you as trustees were also going to be personally liable would depend upon the circumstances and what had happened. So for example, if you as trustees had allowed the treasurer to have sole access to the bank account, to be the sole signatory, and have no sort of checks and balances on how he could take the money out and run away with it, then you might find that you had personal liability. Now, because that's an issue internal to the charity that relates to your duties as trustees, it is not something where limited liability is going to give you any protection at all. The limited liability protection from incorporation is between you and third parties bringing a claim against the charity, as opposed to where you as a trustee have done something wrong, or one of your co-trustees has done something wrong, and you're liable together. The one area that might differ, for example, though, is if one of your trustees were to go and put some very unfortunate comments on social media, then that's more likely to be a claim just against them. And if you were incorporated, it is less likely that any of the other trustees would get caught up in that, and it would be more of an issue for the charity if it was using the charity's social media stream.
So many things to think about. So many things to think about. Thank you, Tim. Thank you very much all for joining us. And if you'd like to see this again, it's been recorded. As I say, it's on the website, the Trust Partnership website, Stone King website. But for now, thank you very much. And we hope you've enjoyed it. And I'm sorry for the glitches at the beginning, but I think we got there in the end. Good afternoon.